Every non-disclosure agreement covers certain kinds of information, but not all kinds of information. The question is, what information is covered by this or that confidentiality agreement? Well, the answer is the information it covers is the information it says it covers, and there are several ways, several different approaches to how one describes what a non-disclosure agreement covers, what information should be considered confidential. Now, and the reasons that we define the information one way or the other depend upon whether we expect primarily to be the discloser of information or primarily to be the recipient of information covered by the NDA. If I expect to be the discloser of most of the information that's covered by the agreement or all the information that the agreement is going to cover, then I want the definition of confidential information to be very broad. I might, for example, say that all non-public information that the discloser provides to the recipient is considered confidential information for purposes of the agreement, and then anything which fits that definition is subject to the rules that are spelled out by the contract. On the other hand, if I'm the recipient, or expect to be primarily the recipient of information covered by the agreement, then I'll want the definition of confidential information to be far narrower. I might, for example, say that it is only the particular information to be disclosed on a certain day or at a certain time or in a certain manner or in a certain document. You can list those things and be quite specific. The most common approach to trying to be reasonably narrow is to say that it is information which is marked as confidential, that there must be a proprietary notice on each document which is provided or each written item which is to be protected. And that if information is disclosed orally, it is not protected unless at the time it's disclosed the speaker, the discloser, identifies it as confidential information. Hey, what I'm about to tell you, I intend to be considered confidential information. And then ordinarily the agreement would require that there be a follow-up promptly after that disclosure in writing describing the information having been disclosed and reaffirming that it should be considered confidential. We try to make it narrower that way so that we know what our duties are as recipients. If there are lots of categories of information being provided to us and we can only provide confidential information to certain people or can only use that information in very narrow ways, then we want to know what fits that description and what doesn't. If it doesn't fit that description, we are freer to use the information as we'd like. So the definitions of confidential information usually fall somewhere on the spectrum between whether we expect to be discloser or recipient. We may say it's all non-public information or all information which a person, which given the circumstances of disclosure or the nature of the information, any reasonable information would, any reasonable person would expect to consider confidential. That would be a broad definition, or something far narrower by listing the actual documents or information to be disclosed, or giving it a very tight marking obligation. So what's covered by the contract is what the contract says it's covering, and we have several approaches, but generally it's on the spectrum of whether we expect to be one party or the other.